Hello and welcome back. We're concluding our lecture on freedom of speech, assembly, and association with a lecture on hate speech and the right not to speak. So let's get started. So how do we define hate and offensive speech? The court has said that it is speech that arises from hostile, discriminatory, and prejudicial attitudes toward another person's innate characteristics, and these include sex, race, ethnicity, religion, and sexual orientation. Um, Usually, the court does not view these as political speech in the traditional sense. And the important point here is that the central aim of the speech is hostility, not advocacy of a political idea. So the court is not shutting down people making statements with respect to those innate characteristics, religion or sexual orientation or what have you. It is saying that when the speech itself is directed solely at the individual who has those characteristics and not directed at matters of public policy, then that speech is not necessarily protected. So obviously there's a great deal of tension here between the free speech rights of individuals and the fundamental concept of equal protection that we find in the 14th Amendment. In other words, there's a tension between the rights of individuals to speak and to explain and promote particular ideas that they have, and the rights of individuals who are members of particular classes to gain equal footing in society and be treated fairly and equally. This tension is going to come up more and more in cases that will come before the court shortly involving sexual orientation and same-sex marriage. We've already seen some of that tension. An individual who opposes same-sex marriage might want to express those views in an effort to change the political system, and members of that discrete class of individuals who are homosexual or lesbian or bisexual, they may feel threatened as a group. And what we have at that point then is at least one individual right, possibly two if you combine it with religious expression, an individual right that an individual can claim, and then a right to equal protection that members of a class can claim. And how the court sorts that out in terms of the clash of these two fundamental aspects of civil rights and liberties is yet to be determined. Okay, so one of the first cases, and an important case, I think, for understanding hate speech jurisprudence is the Skokie case. This was a case in which a city refused to allow the Nazi Party of America to march in the streets, refused to issue them a permit because the city did not favor the speech and did not want to appear to be endorsing the speech. The court allowed the Nazis to march, but this case isn't precisely a hate speech case. It's more like a free speech case involving content neutrality and viewpoint neutrality. The first real case involving hate speech was RAV versus St. Paul, which is discussed in your book. Now, this was a case involving a local ordinance, local regulation in the city of St. Paul, Minnesota, that banned offensive expressions using symbols. And some of these offensive expressions would involve the use of swastikas or burning crosses, both of which are symbolic acts and symbols that are associated with racial purity and racial hatred. So in this case, a minor, that's why it's called RAV, they didn't use his name, but a minor burned a cross in the backyard of an African American family, and he was punished not for trespassing or for setting an illegal fire in city limits, but for expressing hatred using these symbols that the ordinance banned. And the majority in the court struck the law down and said that it was content-based and discriminated on the basis of the viewpoint expressed. So if someone had lit a fire in someone else's backyard, they might not have been punished. But since that fire was lit in this case and on a cross, right, a wooden cross was burned, that these individuals were punished for hate speech, whereas other people basically engaging in the same act were not. Another case, and this one is excerpted in your text, Snyder versus Phelps. This is a case involving the Westboro Baptist Church. And the question there was, do citizens have the right under the free speech clause to protest at military funerals, even if that protest might cause people at the funeral or family members of the deceased severe emotional distress? And the court said that yes, the individuals have a right under the free speech clause to protest at military funerals. Justice Roberts writes the majority opinion. Court says that the speech, however offensive it might be, was at a public place, it was on a matter of public concern, and it was entitled to the protection of the First Amendment. So the Westboro Baptist folks were legally occupying that public space. That public space, actually, it was usually done in traditional public forums like on streets or sidewalks. And there was no reason to ban that speech simply because the harm that might occur as a result of it. And in fact, you begin to wonder at that point whether there is much of a way for the state to ban speech that involves matters of public concern, no matter how offensive, simply because of the potential for violence to occur. Well, after reading this decision, groups that opposed Westboro Baptist's viewpoint on the death of United States soldiers being God's punishment for endorsement of homosexuality in the nation, etc., etc. These people who opposed Westboro, they decided, well, we'll make use of the traditional public forums too, and there's actually a group that follows them around from funeral to funeral protesting their protest. What's good for the goose is good for the gander, apparently. In Morris versus Frederick, this case is also excerpted in the text. You should look closely at it. This is a really interesting set of case facts. This is the Bong Hits for Jesus case. So a young man is a student at a public school, and the public school hears that the Olympic torch relay is going to be coming in front of the school, on the roadway in front of the school. So he leaves the campus of the school and walks across the street, and as the torch relay goes by and the cameras turn on, he unfurls this sign along with some friends. He unfurls this sign that reads, "Bong Hits for Jesus." One has to wonder a bit about exactly what he was attempting to express at that point. The principal of the school suspended him because he refused to comply with his command to stop displaying the sign, but it suspends him for violating a school rule that prevents advocacy of illicit drug use. This is a very difficult case. It's problematic for me for several reasons we'll discuss in just a moment. So the question is, does a principal's restriction at a school event, I'm not entirely certain that it was, of student speech that might reasonably be reviewed as promoting illegal drug use violate the First Amendment? The court said no, obviously a closely divided court. Here's what Chief Justice Roberts said. Students in a public school setting do not have the same constitutional rights as adults in normal settings. Well, what case have we discussed in which the court said that students don't check their free speech rights at the door? Well, that was Tinker versus Des Moines, Iowa. It involved a nonviolent protest. Of course, he goes on to say that while students do not completely lose their rights at the schoolhouse door, the nature of the rights must be appropriate for school and children. This is difficult for me on two levels, actually possibly three. So first of all, they weren't on school property. They had left school property to display the sign. The court looked at that and said they're not going to make any distinction between it. It was a school day, and the school had involved itself in the Olympic torch relay. Um, so that to me, however, is difficult because the students are not on the campus at the time. Secondly, this was advocacy of something. I'm not exactly sure what bong hits for Jesus means, but it was advocacy of something, however juvenile that might be. And as we know, advocacy of certain ideas is protected. If we can't figure out, however, what that juvenile remark means, how can we say that it was advocacy of illegal drug use? I'm not certain that you can say that it was juvenile and didn't mean anything. It was asinine, and then on one hand, and then on the other hand say this is clearly a violation of the policy for advocating drug use. Thirdly, if it is advocacy of drug use, let us say for a moment that it is, why is it that students cannot advocate drug use? Now, the policy says advocate in any form. Why is it that students could not make an argument in a classroom for for the legalization of drugs in a school setting? Would they be punished for that? I think after this case, perhaps the students at the school would be unsure of what kind of case they could make, and whether they'd be violating the policy simply by speaking, even in a classroom setting. Okay, and then we'll conclude with this right not to speak. This involves some cases that we've discussed already. The Gobitis case and the West Virginia versus Barnett case. These deal in part with religious rights. So we talked about these as part of the religion clauses section of the course. But this was the case in which the Jehovah's Witnesses, the children in Gobitis, were punished for not saluting the flag, and then 3 years later the Supreme Court changes its mind, and in West Virginia Board of Education versus Barnett, it revisited this question, the same question. May a state, consistent with the First Amendment, force students to salute the American flag and recite the Pledge of Allegiance? Now, as we know, Jehovah's Witnesses object to these kind of displays. They see it as as idolatry, and they won't take pledges, and they will not recognize idols of which they think the flag is one. And the justification in the first case, the Gobitis case, the justification for punishing the students was that the school district has a legitimate interest in promoting patriotism. Well, that indicated to the public that Jehovah's Witnesses were not patriotic. And so there was a lot of violence that broke out against Jehovah's Witnesses in the 4 years or 3 years between the two cases. The Supreme Court actually noted that and changed its mind. It said that states do not have an interest in promoting patriotism that overrides the religious principles of individuals. So the court says, no, the state may not force students to salute the flag. And Justice Jackson writes that the 14th Amendment, as now applied to the states, protects the citizen against the state itself and all of its creatures, and none of them can act beyond the color of law, beyond the reach of the Constitution. And thus he says that the free speech and religious rights of the students outweigh the interests of the school district. In University of Wisconsin versus Southworth, this was an interesting case. Southworth objected to the use of money that he paid in student fees to the University of Wisconsin to fund student organizations for which he had both religious and ideological objections, including gay rights groups and the like. He wanted to be able to pick and choose where the money that he paid the state was paid. So the court rules that universities must use student funds in a viewpoint neutral manner. In other words, even though the money came from someone who may have religious or ideological objections to the funding of the group, to allow the university to direct more money to some groups than others is to, in effect, to promote certain viewpoints over others. So Southworth lost his case. All right, thank you very much for your attention.